Welcome again to this afternoon's employment law update. My name's Ramez Musa. I'm a partner in the Birmingham employment team of Squire Patton Boggs, and I'm joined today by my colleague Joe Galbraith, who is a senior associate in the Birmingham Labour and Employment team as well, and we'll be jointly giving this morning's update. I'll start off with a few things and then Joe will take over later. Just a quick few housekeeping points before we start. Throughout the webinar, everyone will be on listen-only mode. So if you do have any questions, you can submit those by clicking on the Q&A button, which you should see on your screen somewhere, should be at the bottom right-hand corner, I think, and selecting all participants, all panelists from the drop-down menu, and then we'll see your questions come through. And although we've got a lot to get through this morning, this afternoon, hopefully we'll have some time at the end to deal with some of those questions. And if anyone is experiencing any technical difficulties, you can use the same function, but on the drop-down menu, just select host and you can submit your technical question there. If you submit your technical questions to all panelists, Joe and I will probably have no chance to be able to help you. So please do that. And at the end of the webinar, we'll also be circulating the slides and a link to the recording as well, in case you do have to drop off early or you'd like to share that information with any of your colleagues. So on to this morning's update. And in terms of employment law changes, there's actually currently nothing significant coming into force this year. But that doesn't mean you can log off just yet for your early cup of tea. There are a raft of new proposals and changes in the pipeline, some of which we know about, some of which we're anticipating, some of which we know will come into force at some point over the next 12 to 18 months. So we're going to be looking at all of those, or the majority of those, briefly in just a moment. And of course, we do also have a general election coming up at some point next year. We don't know when that will be. We think it's likely to be the autumn. There are some commentators saying it might be spring, but it's likely to be later in the year. And although a lot of these proposals are Conservative proposals, and Conservative government may push them through, may be able to push them through before the next election, a lot of them are family friendly. And it's likely, therefore, that even if the Conservative government is unable to push through some of these changes before the election, Labour are likely to be supportive of these changes, and therefore they're likely to go through in any event. And actually, if Labour do win the next election, then we're likely to see even more widespread employment law changes. Some of you will no doubt have seen Angela Rayner's speech at the TU Congress last week, where she pledged to work with the trade unions to bring forward a new employment law bill within 100 days of taking office. And no doubt that will include a further raft of changes as well. So let me just move the slides along before we have a look at the first thing that we know is coming into force. And this, as I say, the first few slides are going to be in relation to a raft of family-friendly rights, which we know about and which are proposed. And the first of these is this new act, the Protection from Redundancy, Pregnancy and Family Leave Act 2023. And what this act is designed to do is effectively introduce or allow the government to introduce new regulations to provide additional protection for mothers during and after pregnancy or maternity leave. And it's been introduced following some recent Equality and Human Rights Commission research, which suggested that something in the order of 75% of mothers surveyed had experienced discrimination or potential discrimination at work as a result of being pregnant or taking maternity leave, and that apparently or approximately 54,000 new parents each year lose their jobs because they're pregnant. It's obviously far too great a number. And currently, as you'll no doubt know, we have what's known as the Regulation 10 right protection, and we call it the Regulation 10 right protection because of the section of the regulation that it comes from. But under that existing protection, mothers and those on maternity leave have the right to be offered, not just invited to apply for, but the right to be offered a suitable vacancy where one exists in the business in preference to anyone else where the mother's role is at risk of redundancy during their maternity leave. Similar protections also apply to those who are on adoption leave or on shared parental leave. And what these new regulations will do is actually extend that protection. So it will extend that protection from the moment that a mother informs, or a prospective mother informs her employer that she is pregnant, and it will then extend on during maternity leave and for a period of time following the mother's return from maternity leave. And we think that'll be up to 6 months from the date that they return from maternity leave. And again, similar rights are proposed to be given to those returning from adoption and shared parental leave as well. So we don't yet know exactly when these new rights will be implemented. We think they'll be next year at some point, likely not before April 2024, but they're pretty certain to be coming into effect. We'll need to see the new draft regulations once they're actually published to see the exact detail of these changes. So in terms of practical steps, nothing to do at the moment, but obviously keep an eye on these new regulations once they're published to see the detail. And once we get close to the implementation date, it will just be important to make your managers aware of these new rights when going through redundancy exercises. Make sure they're familiar with these new rights so that they don't fall foul of the protection they're given to mothers and those on adoption and parental leave when they come back. On to the next change. There are also new statutory rights coming into force for those employees with responsibility for a child who is receiving or has received neonatal care. Now, the Office of National Statistics reports that around 100,000 babies every year are admitted to neonatal care following their birth, and that many of these babies spend prolonged time in hospital to deal with the complications arising from their premature birth or other health complications arising. The aim of this new legislation, it's stated, is to provide certainty for both employees and employers as to the parent's right to take leave in such circumstances, because currently there is no dedicated right and parents are required to take other forms of leave in these kind of circumstances. So what these new rights will do is introduce both a statutory right to leave and also a statutory right for pay in some circumstances. So in relation to the right to leave, eligible employees will be entitled to, we think, still waiting for the detail, but we think up to 12 weeks of leave each year, sorry, not each year, within the first 68 weeks of the birth of the child, likely to be taken in blocks of 1 week or more for the purposes of looking after their children. It's likely to be a day one right, which means employees won't need any qualifying length of service to be able to take their right to statutory leave. But those employees with 26 weeks or more of service will be entitled to be paid at the prescribed statutory rate of pay, and that will be a similar rate of pay as with other family-friendly prescribed rates of pay, such as statutory maternity pay and so on. There's also going to be a new right introduced, again, similar to other family-friendly rights, which will protect employees from detriment and dismissal if they seek to exercise their new rights. Again, no absolute certain date for implementation yet. We're still waiting for the regulations. HMRC are also going to need to do a lot of work in order to update their systems in anticipation of these new changes. So to allow that to happen, we think that this will come into force sometime in 2025, probably no earlier than May 2025. Given the challenges that HMRC are facing at the moment in respect of other areas, it may well be pushed back a little bit further than that. But again, it's very much a watch this space and let's wait to see what happens. Obviously, when the time comes, then this will also require an update to policies and procedures, manager awareness, staff awareness of these new rights, and also employers may want to consider if they want to enhance these rights in any way. Obviously, many employers already enhanced their maternity benefits, their paternity benefits, parental leave, etc. This might be one of those other areas where employers may want to do a little bit more than simply what the statutory minimum requirements are. There's also going to be new rights introduced for carers. So it's estimated at the moment that something like 2 million people in the UK are balancing their unpaid carer responsibilities with work responsibilities. And that's on average about 600 people per day have to leave their employment because they're simply unable to balance those competing interests. And part of the reason for that is that currently there's no dedicated type of leave for individuals to take time off to carry out caring responsibilities. They're required to rely on other forms of leave, such as holiday or emergency dependence leave, which isn't always applicable in these kind of circumstances. And this issue is obviously only likely to increase. We know as a society we're getting older, we're living longer, more and more people are undertaking these kind of caring responsibilities. So the new act, one of the aims of the new act is stated to be to enable carers to better balance their work and caring responsibilities. Whether this goes far enough or not, we'll wait to see, but it's certainly a start. And what will happen is that once these regulations are implemented, then eligible employees with the right to take this kind of leave will be entitled to 1 week's unpaid leave per year for the purposes of providing or arranging care for a dependent with a long-term care need. Now, it will be a day one right. So again, we're seeing this as a common theme now amongst a lot of different types of rights. Employees won't need to have any qualifying length of service. What's also interesting is that as the proposals currently stand, there's also going to be no requirement to provide evidence of an individual's right to take this kind of leave. They're simply going to be able to submit their requests and the requests be dealt with on that basis. So we can see that there is the potential for some kind of misuse in these kind of circumstances. Again, I think that will need to be addressed in updates to policies and procedures and wording along the lines of, if individuals are found to be abusing these rights in any way, then clearly that can lead to disciplinary action. That's something that you can obviously look at once the regulations have been implemented and once we've seen the detail of the regulations in a bit more detail as well. Similar to the other types of family-friendly rights and what I've also just been talking about previously, there again will be a right to individuals not to suffer any detriment or dismissal as a right of making these kind of requests, presumably as long as they make the requests in good faith and that they're genuine. And again, we've got no specific date yet for implementation, likely to be next year, but no earlier than April 2024. So again, a little bit of time just to consider these changes, wait for the regulations to come into effect. We'll see the detail of them. And then, as with all of these things, it'll be a case of reviewing and updating your policies, making staff and managers aware of the new rights, and also considering whether you do wish to enhance these new rights in any way. Some changes to the paternity leave regime as well. These are relatively minor, but I think they are helpful and I think they are good changes. So you'll be aware that currently eligible employees who are entitled to paternity leave have an entitlement of up to 2 weeks, and they must take that leave either in a block of 1 week, in which case they lose their right to the other week, or in a block of 2 consecutive weeks. And they've got to take that leave during the first 8 weeks following the birth of a child, or this also applies to adoption in the first 8 weeks following a child being placed for adoption. So going forwards, what the government has said is that it will be changing these entitlements so that eligible employees will be able to take their 2 weeks in separate blocks of 1 week, so they don't have to be consecutive, and they'll be able to take those 2 weeks in separate blocks at any time during the first year following the birth of the child or following the date that a child is placed for adoption. And the government has said that it's also going to change the notice requirements to make these more proportionate to the amount of time that is actually being taken off in these kind of circumstances. So at the moment, employees need to give their employers notice of their request to take leave and the date that they want to take leave 15 weeks before the expected week of childbirth or the date that a child is placed for adoption. And of course, that is so early, individuals struggle to really know at that time exactly when they might want to take the leave and how they want to plan ahead for it. So the proposal going forward is that actually those notice entitlements will change, those requirements will change. Employees will need to give their employer notice of their entitlement or of their request that they're likely to want to take leave 15 weeks before the expected week of childbirth, but then they only need to give 28 days notice of the date that they actually want to take the leave. And the intention there clearly is just to enable individuals to be able to plan more flexibly in relation to when they want to take paternity leave. Unlike some of the other changes that we've been talking about, we don't actually even have a date for a target implementation at this stage. The government has simply said that this will be in due course. When that will be, whether that will be next year or the year after, we don't know. Whether it will come into force before the election, again, we don't know, but it's likely to come into force at some point, whichever government is in charge. Again, it's one of those where we just need to keep an eye out for further information. And as and when we have that further information, it will be a case of reviewing, updating policies, staff awareness, education, and so on. And then finally, on the family-friendly side of things, we've got some proposed, well, not proposed, actually, they're upcoming changes. We just don't know when, but they're upcoming changes to the flexible working regulations. So hard to believe that actually this year marks the 20th anniversary of the flexible working regulations first coming into force, which makes me and probably others feel very old indeed. I think many people would say, and a lot of people would say that actually the flexible working regulations have worked quite well. So why tinker with them? But as a birthday present, the government has decided to make some tinkering around the edges, and this followed consultation 2 or 3 years ago about what changes should be introduced. Some of the changes won't have a great impact. So the key changes that are on the slide there: employees will be able to make 2 formal applications for flexible working in any 12-month period, as opposed to the current 1 formal request. Again, won't really make much difference. Employees tend to apply and make informal requests for flexible working, regardless of whether they've got a statutory right to do so or not, and employers will deal with those requests. Employers will also be under an obligation to consult with employees before rejecting a flexible working request. Again, doesn't really change anything that happens in practice now anyway. And the period of time within which an employer is required to deal with a flexible working request will be reduced from 3 months to 2 months. And again, no great hardship there. In our experience, we don't really see flexible working requests and procedures extending for a 3-month period. They're dealt with a long time before then, because everyone needs to know where they stand. So those changes aren't likely to be that significant. There are, however, a couple of changes that I think will be more significant. The first of which is that employees will no longer be required to explain the effects that they think their flexible working request will have on colleagues, on the business, and how those effects and the impact of those effects may be mitigated or dealt with. Now, that was probably a really useful thing to get employees to think about before they made a flexible working request, because sometimes that would lead them to changing their request in a certain way because they see it may not work. And other times it just led to more constructive discussions with the employer, because the employer had actually already considered what the impact of the request would be, and it would enable more of an informed conversation with the employer. That requirement is going to be removed. So actually going forwards, employees will only really need to think about their own personal circumstances when making a request for flexible working. Won't need to think about the wider impact that the request will have. So I think that's probably going to lead to more difficult conversations, or certainly a starting position which might be a little bit trickier. And then the other change, which I think is also quite significant is that the right to request flexible working is going to become a day one right, similar to the other rights that we've just been talking about. So at the moment, employees need to have 26 weeks qualifying service. Going forwards, they'll be able to make a request for flexible working from day one. Now, just thinking that through practically, that means that we may have situations where an employee hasn't even started their job yet, doesn't know what the operational requirements of the role is. For the employer, it may be a new role, so the employer themselves may not know what the operational requirements of that job are. And no one knows whether the individual is going to be actually able to carry out that role. They'll still be in their probationary period. No one will know what the employee's capabilities in that role are. And yet, before any of those things have been established, we are likely to have situations where employees will be asking to work flexibly and will make flexible working requests from day one. And you can immediately see in those circumstances that there is scope for real confrontation and discourse right at the very beginning of the employment relationship. And that could lead to grievances, it could lead to time off for sick. It's not the best footing to start off the employment relationship on. And then presumably, as is the case at the moment, employees have the right not to be subjected to a detrimental dismissal as a result of exercising their statutory right to request flexible working. If employees exercise that right on day one of their employment, then presumably that protection from detriment and dismissal will also kick in from day one of their employment. And you can therefore also see a situation where as soon as someone puts in a flexible working request on day one, regardless of what happens with that flexible working request, if at any point the employer needs to manage that employee because of their performance during probationary or because they're not meeting standards, etc., you can see that an employee may very quickly turn around and say, you're just treating me in this way because I made a flexible working request, aren't you? And again, there is a lot of scope there for discourse and grievances and perhaps litigation. So not quite sure that I can understand the reasons for that right being changed, but we'll have to wait and see exactly how it pans out in practice. The general structure of the flexible working regime in terms of meetings with employees, the grounds upon which flexible working requests can be rejected, all of that won't change really. And despite what some commentators have said and what you sometimes see in the press, this isn't a right to work flexibly. This is a right to request to work flexibly, and it's just being tinkered around on the edges. It will increase the admin burden on employers, no doubt about it, and I think it does increase the scope for grievances and complaints. We'll wait to see exactly what the detail of the new regulations are when they come into force. These changes are expected to come into force in the summer of 2024. Again, we'll see what happens and how that pans out. So again, in terms of practical steps, no immediate action to take. We'll wait to see what the implementing regulations say. But of course, once we have that detail, once we know the implementation date, this will be a case of, again, reviewing your policies and procedures. A lot of companies have standard forms that employees are asked to fill in when making requests. They'll need to be reviewed. And of course, critical to inform and make managers aware of the changes once they come into force. That's all on the family-friendly side of things. I'll hand over to Jo now, who will talk about some of the other changes that are coming into effect.
Thanks, Ram. So yes, firstly, we're going to talk about sexual harassment in the workplace, which is highly topical at the moment for anyone who has watched any news or been on any social media platform in the last week. So yeah, sexual harassment, it's something we still deal with a lot of cases on sexual harassment. We've seen a lot of large organizations really stepping up their game in terms of rolling out new policies, and we've worked with a lot of clients in really strengthening their training program in dealing with sexual harassment at work. So we have seen quite a lot of, I would say, positive change, although the cases still continue to come in. I think there's a little trend that we've seen recently of cases of people having relationships at work that then go south and the kind of the fallout from that. So you do get some large organisations who put policies in place to restrict or prevent relationships between colleagues. It's something that US companies seem far more keen on than we do in this country. And then, of course, I mean, I met my own husband at work, so it's something that some employers feel very wary of wanting to kind of overstep that line. But what's the government doing? Enough about me. What's the government doing in this area? So there was a consultation in 2019 which was looking at whether the current laws around sexual harassment are effective. And in response to the consultation, 2 measures were taken forward, one of which has since been dropped. So the first of these 2 measures is the one that is still proceeding and which we think will become law, although not for at least another 12 months, is a duty on the employer to take reasonable steps to prevent sexual harassment in the workplace. So as with so much of employment law, the word reasonable does the heavy lifting, and it will come down to what is considered a reasonable step and how do you fulfill that duty. So things like the size of the employer, the sector that you work in, those will be relevant factors to when you're considering the concept of reasonableness in this context. It will be important to look at policies, so obviously equality policies, harassment policies, whistleblowing, grievance, those kind of things will all be relevant. And in terms of how enforcement of a breach would come about, there are a couple of ways that employers could be punished for failing to comply with this new duty, which are, one, the Equality and Human Rights Commission could take enforcement action against an employer, or probably more likely, if there was a successful employment tribunal claim brought by an individual who's alleged sexual harassment, and as part of that claim, the employment tribunal finds that the employer has breached their duty to prevent the sexual harassment, has failed to take the reasonable steps, then compensation awarded for that sexual harassment in the tribunal can be uplifted by up to 25%. So that's sort of a more likely consequence of this new law if and when it does come into force. There is going to be a code of practice coming out to help employers to work out what they need to do to ensure that they do comply with this duty as far as they can. And in terms of the second proposal that came out of the consultation that is no longer going forward, this is the third-party harassment. So this used to be law. It was originally the Sex Discrimination Act, and then it was in the Equality Act. It was repealed because it all became a bit messy and complicated, and there used to be a 3 strikes rule, which some people may remember. But it was proposed to reintroduce the potential liability for employers for acts of harassment by third parties, but it was very controversial. I think understandably, particularly for employers in the hospitality sector, it was considered just unworkable and impossible because there would be so many scenarios where you would have employees, for example, working in a restaurant or a bar, overhearing conversations of customers, and then the employer being potentially liable for harassment as a result of that. So that has been dropped. So that probably is certainly welcome to people in the hospitality sector. So moving on to everyone's favourite legislation, the working time regulations. And you won't need me to tell you that working time regulations, in particular the area of holiday pay and the calculation of holiday pay, has become extremely complex over recent years, especially if you have workers who have variable pay or irregular hours. The way holiday pay should be calculated, yeah, it's not straightforward. Although this table that we have on the slide is actually a very lovely, neat way of summarising it, and I think I might need to have it in front of me whenever I'm advising on this in future. So where we are at the moment is that there are 2 types of leave. So when you're on holiday, you may not know it, but you may be on one type of leave, and then the next day you may be on another type of leave. So there's 13 and 13A. 13 Regulation 13 leave is the leave that comes from the Working Time Directive. So sometimes we call it EU leave. It's for 4 weeks. And in the UK, we have 13A leave, which is specifically just under the Working Time Reg. So it's not from the directive. It's the additional 1.6 weeks that we get in the UK, adding up to 5.6 weeks, which is your statutory leave entitlement. The difficulty comes with how the holiday pay should be calculated for those two different types of leave. And it's a lot of EU case law has changed the situation in relation to those types of leave. So in relation to the 4 weeks, various very lengthy, complicated EU decisions has meant that it is not the case that you calculate that by looking at the basic pay. You must look at what's called normal remuneration. And it's been found that normal remuneration is essentially anything that an employee receives on a regular basis. So it does include regular overtime, it does include commission, it can include bonuses, depending on sort of the regularity of those. So that's for the 4 weeks, but then for the 1.6 weeks, that's just basic pay. So it's led to this weird 2-tier system of calculation of holiday pay. So some companies don't even bother splitting it out. They just pay it all on the kind of the normal remuneration principle. Whereas we do know some companies still split the two to make the difference because it is, you know, a cost saving. But it's led to complicated contractual provisions about which type of leave is taken first in a holiday year. Anyway, I'll stop talking about that because the proposal, which I imagine will be welcomed by almost everyone, including me, is that the 5.6 weeks will all be calculated in one consistent way. Now, we don't know what that's going to be yet. The government is going to consult on it, and it's going to take views from employers and workers about how we think the 5.6 weeks it should be calculated. But it would be it would make life a lot easier if that does go ahead. Other changes being considered in the working time regs arena include rolled up holiday pay. So this was something that came a bit from left field. No one really expected the government to sort of move on this, but they are looking to make rolled up holiday pay lawful and a possibility for all workers. So at the moment, just to go back a step, what we mean by rolled up holiday pay is when workers receive a percentage of their pay on every pay slip to account for holiday pay, regardless of whether or not they've actually taken holiday. So it just rolls it up and pay it in one go. At the moment, that's unlawful, although we know that it's a practice that it persists in sectors where people have irregular hours, 0 hours, the gig economy. It's very difficult to calculate the amount of holiday that workers should be having when they work in those kind of sectors. So rolled up holiday pay is a common way of addressing that problem, even though, as I said, it's technically unlawful. So the proposal is that it would become lawful to do it in this way. And someone better at maths than me has worked out that the correct percentage is 12.07% of working hours is what gets you to your holiday pay entitlement. That's based on statutory entitlement. So if an employer also allows additional contractual entitlement, the 12.07 would have to be adjusted to account for that. So we don't know when that will come in or the details of it, but it will be helpful for employers in sectors where they have a lot of shift workers or 0 hours casual type workers to be comfortable to carry on paying rolled up holiday pay. And finally, other working time regs news. The case of Agnew, we are expecting a Supreme Court decision imminently on Agnew. So this was a case that it's deciding a number of issues, but one of the main ones, or really the main one, is whether or not a 3-month gap between incidences of holiday would break the chain of deductions for the purposes of an unlawful deduction from wages claim. So that would be a very helpful thing if employers were able to say you're not able to claim that a chain of deductions if there's a gap of 3 months or more. We think it's unlikely to go that way, and it will probably find that a 3-month gap does not necessarily break the chain of deductions, but we don't know for sure. We're waiting for that decision kind of imminently. So moving on, non-compete clauses. So there's been a consultation on restrictive covenants, but it has been restricted to non-competition clauses rather than the other types of post-termination restrictions we see. So doesn't apply to non-solicitation, non-poaching, those kind of things are left as is. Restrictive covenants are, as we know, they are presumed to be unenforceable unless they can be shown to be reasonable. which means that they must be protecting a legitimate business interest and they must go no further than necessary. And non-competition restrictions are the most restrictive of the restrictions. So they're when you're seeking to prevent a former employee from going to join a competitor, whether working for them or consulting for them or working with them in some way, you're trying to stop them doing that altogether. So as part of the consultation, it was considered whether non-competition restrictions should be absolutely banned outright. It was also considered whether employers should be required to pay a former employee or compensate them somehow during a period of restriction to acknowledge the fact that you're preventing them from earning their wages. So and that's something I think there are other European jurisdictions take that approach of, it's more like a garden leave approach, but instead of being employed there is some sort of ongoing compensation requirement. But they're not doing either of those. But what the government is doing, again, it's slightly surprising. They're saying non-competition restrictions can go no further than 3 months. So and that's pretty short, really. It's not at all uncommon to see restrictions that extend at the moment for 6, 9, 12 months even. I mean, 12 months is pretty unusual. It's pretty tough to get a non-competition restriction for 12 months, but you do see it for really key people and organizations. So we don't know, again, we don't know when this one's coming in, but it does mean that it probably would be a good idea to consider now your restrictions in regards to key senior employees, because if any of your non-competition restrictions are currently unenforceable, or there's a risk they might be because of the width of the drafting may be too wide, it would be much easier to change those restrictions now than it would be after the new law comes in, if it does. So a word on fire and rehire, also known as dismissal and re-engagement. There's a draft code that has been issued on how employers should behave in a fire and rehire scenario. We think this has come out because during the pandemic, we saw several large employers carry out these kind of exercises. It's very unpopular with trade unions. It generates negative press. It was kind of seen as opportunistic, I think, in the pandemic, because employers, or some thought that employers were sort of using it as a chance to change terms and conditions. So it's very unpopular, but it is a totally lawful way of proceeding. The code is supposed to sort of, regulate how employers do this. We don't know the details of it yet, but it will have statutory force in that if an employee brings a tribunal claim and has been through this sort of dismissal and re-engagement process, and it is found that the employer has unreasonably failed to comply with the code of practice, then again, the tribunal will have the power to uplift compensation by up to 25%, although it can also reduce compensation by up to 25% if it finds that the employee has unreasonably failed to comply with the code. So there must be some obligations for employees in that code, probably to attend meetings and engage with the process, etc. And it's worth saying as well that the code will apply regardless of the number of employees that will be affected by the exercise. So it's not just for collective consultations, it's for any changing terms and conditions which would involve a dismissal and re-engagement at the end of it. Next thing to say, there's not very much to say about this. I think this is one of the things we were expecting the government to do more, to be honest, to change the TUPE regulations, but the changes are negligible. So it's in relation to small businesses with fewer than 50 employees and small transfers where there are fewer than 10 employees that are transferring. In both of those scenarios, rather than having to elect employee representatives to consult with, it will be permissible for employers to just consult directly with the employees affected, which, to be honest, is what everyone does anyway, I think, for that size of transfer. So nothing really to see here. And tips and gratuities. So there is a new Act of Parliament which we are expecting to come into force in May 2024, where there will be an obligation for employers to allocate tips fairly There'll be new rights for workers as part of this, so they will have the rights to request information about how tips are paid. They will be protected from detriment for raising queries around tips. Obviously, this isn't relevant for everyone, but there will be a code of practice as well for this one to explain the ins and outs. And then a few other things. Well, there's quite a lot of other things, but they're all sort of floating around, and we don't know to the extent to which these may or may not be coming into force. So I'll pick out a few that I think are interesting. Ethnicity pay gap reporting. So obviously the gender pay gap reporting, after that came in, there was a lot of discussion about other types of reporting that may be required. The government has said that they are not going to introduce mandatory ethnicity pay gap reporting, so it's still voluntary. I think some companies do comply with, they do not comply, they do voluntarily report on their ethnicity pay gaps, but it's not going to be mandatory. Predictable terms and conditions, a bit of an unusual one. This actually received royal assent a couple of days ago, so we think this one will come into force probably around this time next year. And this is for workers with unpredictable working patterns will have the right to request a predictable working patterns. And the employer will have to deal with the request in a reasonable manner and reject it only on specified grounds. So it's very similar to a flexible working request, but it's a predictable working request. It also will apply to agency workers and anyone on a fixed term of less than 12 months, a fixed term contract of less than 12 months. So that is expected next year, as I said. And then the Economic Crime and Corporate Transparency Bill is it's not strictly an employment measure, but it's relevant for large employers, and it will create a new corporate offence of the failure to take reasonable steps to prevent fraud from occurring, and it can be really significant. There's a potential unlimited fine for that. There is guidance to come out on that, so it's just one to have on your radar. A couple of other things. There is a sort of a potential for bullying to be defined in legislation. This has been pushed forward by various MPs. It would be similar to the definition of harassment, we think, but it would not be tied to a protected characteristic. So there's potential for that to massively increase tribunal claims because bullying, it's so subjective. Yeah, we don't know yet if that's going to go ahead. It's one of those floating around ideas. And then one thing that we do think is going ahead is changes to the auto-enrolment pensions regime, because the bill just passed the House of Lords this week, although regulations are still required to implement these changes. But the powers have been passed for the Department for Work and Pensions to lower the age for auto-enrolment. So it's currently 22, but it may be lower, and lower or remove the lower earnings limit for qualifying earnings. So I think it's generally because the government's concerned about state pension and about the aging population, and so they're trying to beef up the auto-enrolment regime, I suspect, is what's going on there. But we think that will come into place next year. And so that is it from me. And so Ram's going to talk about other trends we are seeing at the moment.
Thanks, Joe. And yeah, we thought we'd just spend a couple of moments at the end of this webinar, just really sharing what we're seeing at the moment, what type of queries we're getting from our clients, and maybe where we see the direction of travel in relation to some things. So we've listed a few on the slide there. There are obviously ongoing challenges arising from the cost of living crisis. This has been with us for quite some time now, probably over a year. At the initial beginning of that period, a lot of companies we saw were stepping in with the provision of financial assistance to employees and workers. So things such as wage increases, one-off bonuses, loans, that kind of thing. And I think what we're seeing is we're at a stage now where companies just don't have any more money to be able to provide that financial assistance. And so what they are doing is actually thinking of or looking at other types of assistance that they can be giving to their employees, non-financial. So things such as the provision of employee helplines and counselling services if they don't already have those kind of benefits in place, bringing in external consultants to give webinars about debt management, financial planning, that kind of thing. Loans spread out over a longer period, subsidies, canteens, sandwich trolleys, that kind of thing. A lot of things that, as I say, are kind of non-directly financial, but will still be of assistance to employees. And the reason for that is obvious, not just from sort of a moral or ethical perspective, but also financial worries clearly have an impact on employees in terms of their performance, in terms of their productivity, in terms of their well-being. So anything that companies can do to help employees will ultimately also help themselves and help towards workplace culture as well, which is something else that we're seeing is of particular importance at the moment, particularly following COVID. I think companies do need a clear strategy in terms of how to deal with these ongoing challenges because they are going to be around for a little while longer. We are also seeing an increasing number of queries in relation to redundancies and restructuring following sort of the cost of living theme. Probably fair to say not as much as we thought, whether that's still in the pipeline, whether that's still going to happen, but we are starting to see some increases in that kind of activity. There are still also a lot of issues arising from the new working arrangements. Sort of in the post-COVID world, particularly in terms of hybrid working, working from home, working in the office. We've seen a lot of press coverage recently in relation to some of the bigger companies now scaling back on their working from home arrangements, whereas previously they'd allowed employees to work from home 3, 4, 5 days a week. We're now seeing a lot of big companies reversing that and saying, well, actually, you now need to be in the office 3 or 4 days a week at least. That's creating some real friction, I think, in relation to employees' expectations, the mindsets, the ways of working that employees have got used to following COVID. And paradoxically, whilst we're seeing some companies do that, we're still also seeing an increasing number of queries from clients relating to employees who are asking to work flexibly abroad. Because they feel that they've been able to do that successfully for the last year or two and they want to continue doing so. And that obviously creates a lot of implications from a tax perspective, from an employment law legislation perspective, from a corporate perspective. There are certainly some competing interests going on there. And I think what is clear to see is that the landscape hasn't yet settled down sort of following COVID. We thought it may well have done by now, but it's fluid and it will continue to be fluid for quite some time, I think. The issues with these new working arrangements also creates operational issues such as the effect that it has on the glue, the workplace culture, that thing that binds people together, that binds people to organizations. If they're not at work, if they're not speaking to their colleagues, if they're not collaborating, then a lot of that kind of essence is lost. And again, a lot of employers are kind of still struggling, I think, to find the right balance between what's good for them and what's good for employees and hanging on to their talent and retaining employees as well. One of the things I think, and it kind of thing I think ties in with this and workplace culture generally, is we're certainly seeing an increasing number of grievances, of complaints, of worker dissatisfaction. Whether that's a legacy of COVID, whether that's because employees were at home for so long or were just in such a bad, well, we all were in such a bad place for 2 and a bit years. A lot of employees and workers kind of taking a long, hard look at what they want out of life, what makes them happy, what they want to do going forwards. We're seeing a lot more people being now vocal in terms of things that they don't like at work or complaints or grievances. We're seeing as soon as an employee is managed or performance managed or criticized, those kind of things that a number of years ago you'd say, well, that's just part and parcel of being in the workplace. We're now seeing an immediate reaction from individuals to those things, often resulting in individuals going off on sick as well and then bringing grievances. So that's creating some real challenges. There's no magic bullet in terms of how to fix those things, but it does go towards making sure you do have a strong and healthy workplace culture by whatever means you're able to do that. Environmental, social and governance issues, ESG, they continue to be prominent. Again, it kind of ties in with some of the things we've been talking about in terms of workplace culture and so on. A big part of that is diversity, equality and inclusion. We're seeing a lot of companies, and they have been for the last few years, but I think increasingly so, now really looking at their DEI strategy, looking at their policies and procedures, looking at workplace monitoring, trying to really understand what's going on in their business and how they can create a more inclusive work environment. And tied with that, and something that I think we will certainly see more of, are issues relating to gender identity and gender recognition and trans issues. They've always been around, but you used to get one query every, once in a blue moon on those kind of issues. We are now seeing an increasing number of queries in relation to those areas as society shifts, as government thinking and other bodies thinking changes. Still a very moving area of the law. A lot of our clients are coming to us and asking for assistance with implementing and putting into place policies and procedures to deal with these kind of issues. It's a really difficult thing to do because it's such a fluid and moving area. But it's something that companies and clients probably should be thinking about, even if they haven't introduced anything already. And then I think the last thing on the slide there we've mentioned is artificial intelligence. We are seeing that usage of AI is becoming increasingly prevalent in workplaces, in businesses. I think it will continue to do so. It's only going to go in one direction. It poses a whole load of legal complexities and challenges in relation to things like workplace privacy, discrimination issues, how are algorithms coded, what impact does that have on individuals, breaches of confidentiality and trade secret issues that arise, and impacts on employees generally. They're worried about their jobs, they're worried about job security. I think those kind of issues are only going to go in one direction. And I think it's certainly one of those areas where keep an eye out on developments and how things shift. We will in future webinars be looking at artificial intelligence in a bit more detail, or perhaps one of our bots will be, we don't know yet, but keep an eye out for those and we'll share information and knowledge as soon as we get that ourselves. So that brings us to the conclusion of today's webinar. Thank you very much, everyone, again for participating. I hope you found it helpful. We have had a number of questions which we've done our best to try and respond to as we've been going along today. Apologies if we've not been able to get around to all the questions you've asked. We'll try and follow up with you on those questions after the webinar if we're able to do so. If you do have any questions following today's webinar that you haven't thought about as we've been going along, or that you have after the event, again, please do reach out to us. We'd be delighted to hear from you, and we'll get back to you as soon as we can do. A reminder again that our slides to this session and a link to the recording will be circulated again after the update this morning. So thanks again, everyone. Hope you enjoyed it and enjoy the rest of your day. Thanks very much.